Hello, welcome to this recording about the Articles of Association. Now, the Articles are a very important document for a company because these are effectively the constitution of the company. It's the main document that sets out things like the share rights, the rights to share in a dividend, the rights for share transfers, rights to capital on a winding up, voting rights. Also, details like how do you appoint and how do you remove a director? What happens if you want to wind the company up? What happens if you want to change its name? Things like that. Now, lots of these things are actually covered in the Companies Act anyway, but it's possible for the articles to override some of the Companies Act provisions. Now, if you don't provide articles when you set up your company, it will be assumed that you want to use the model articles. And these are something which are attached to the Companies Act. And there's a special version, there's one for limited companies and there's one for PLCs. You could substitute instead of this your own version, or you could just amend the model articles and just change those provisions that need to be changed for your particular company. Now, if you think about it, when you actually buy shares in a company, you're entering into some sort of agreement, because if you weren't, how would you know what your rights were and how could you enforce them? Now, the Companies Act provides that when you are a shareholder, it's as if you have signed a written contract, an agreement between yourself and the company and the other members of the company. So you might have shareholder 1 and shareholder 2 and the company. And what the Companies Act says is it's as if you have an agreement. But it kind of works like that between shareholder 1 and shareholder 2, but also between shareholder 1 and the company and shareholder 2 and the company. Now, from time to time, the company may deal with other people like customers or even suppliers. Now, they will have a contractual relationship with the company, but of course, in each case, the contract will be negotiated with the customers or with the suppliers, and it's the terms of that contract which will govern their relationship. So the contractual effect of the articles is actually limited to the agreement between the companies and the various shareholders. Even more so, this agreement relates purely to rights that they have in their capacity as shareholders. So if you think about the rights you'd expect to get as a shareholder, you'd expect to be able to vote. You'd expect to be able to attend shareholders' meetings. Maybe you'd expect a dividend. It's these kinds of rights that are what we call shareholder rights or member rights. And it's only these kinds of rights that this contractual agreement relates to. Now, that point was tested in this case here called ELI, the Positive Government Security Life Assurance. If you just remember it's the ELI case, that's going to be fine here. Now, what happened here was that Mr. Ely, there he is, was asked to draw up the documents for a company. And Mr. Ely was the company's solicitor, so he thought it would be a good idea to give himself a job for life. So he wrote into the company's Articles of Association a provision that said he would always be the company's solicitor. And then, because he was aware of this rights as articles as a contract thing, he also bought some shares. So he was now Mr. Ely, the shareholder as well. Now, over time, the company fell out with Mr. Ely and they wanted to sack him as the company's solicitor. However, Mr. Ely said, well, you can't, because I have this provision in the articles. Remember, that's a contract. It's binding on you, the company, and me, the shareholder. And it says that I will always be a solicitor for the company. Now, the court said that wasn't the case at all, because remember, the contractual effect of the articles is limited to your rights as a member of that company, your shareholder rights. So his right to be employed as a solicitor is not a member right. Now, we can take that a little bit further, because sometimes you will see that directors might have clauses written into the articles about, say, their remuneration, or again, their contract length, their job security. Now, the law says that if you have a term like that in the articles, it doesn't protect the director from being sacked, because the articles can be varied by the shareholders, and you can't stop them from doing that. However, if you can show that this provision is evidence of the terms of your employment, then that may well give the director a right to sue the company for breach of employment contract, basically wrongful dismissal. So the director may be able to justify a claim against the company, but he's not doing it under the provision of the articles. He's doing it by showing that that provision reflects a contractual agreement between himself and the company, but that contract is not part of the articles. If you do change a provision in the articles, that's always going to be looking towards the future. So if a director already has a certain amount of bonuses that have accrued according to the term that's written into the articles, he's still going to be entitled to that. Now, changing the articles. If a company wants to change the Articles of Association, you need a special resolution. So 75% or more of your shareholders would have to agree. Now, some provisions, you might want to make them a little bit more secure. So for instance, if you have an owner-managed business and all of the directors are actually shareholders in the business, they might want to make sure that the other shareholders couldn't gang up and remove them as a director. Remember, you only need 50% plus one vote to remove a director. So what you might do is you might put a provision in the articles that says you need 80% of the votes to remove a director. Now, that on its own isn't good enough because that won't protect the director, because you only need 75% of the votes to remove that provision from the articles. So what we do is we can entrench certain provisions. Now, an entrenchment means that you make it more difficult or to change a provision of the articles. Now, the law says you can provide that a certain provision in the articles can only be changed if everybody in the company agrees, i.e. 100% of the shareholders agree, or with a court order. But what you can't do is put a provision that says a particular term of the articles can never be changed. That's not allowed. It must always be at least theoretically possible to remove that entrenchment provision. If you do change the Articles of Association, you must send a copy of that article to the company registrar within 15 days, and that will also become part of your constitution. We'll add that to the articles, and it becomes one of your governing documents. Constitution. Another point about changing the articles, again, you can only change the articles in a way that looks to the future. You can't make any retrospective changes. Also, you can't force an existing shareholder to take more shares or to take on more debt. Okay, you can ask him to, and if he agrees, that's great. But you can't, sort of by a majority vote, force certain shareholders to accept more responsibility for the company. Okay, so this is a fairly short section about the Articles of Association, but it is quite important that you understand that, and it's a point that's often tested. So we'll leave that there, and then we'll come back shortly to look at administration.